Hello and welcome to today's webinar. Can I just ask everybody to use the chat box to tell me if they can hear me? Okay, that would be very useful. Just a quick yes, you can hear me. That would be fabulous. Excellent. So thank you everybody for giving me some of your time today to listen to the webinar that I have entitled GDPR Says No, But Does It? So what I want to talk to you today is about some typical statements that I have heard more than once over the last 18 months. And I want to give you the response because you may well have heard that too. There will be an opportunity at the end of the webinar to ask me any questions because there may be some statements that I have not covered, and this is your opportunity to tell me or ask me those questions. The webinar is being recorded, so for anybody that is not able or hasn't been able to join the webinar today, the webinar will be available via our website within the next 72 hours. So, without further ado, let's kick on. So I want to talk to you today about how data protection can be a framework for supporting your growth as an organization through marketing, sales, and digital marketing, and not seen as a barrier. My name is Kellie Peters. I am the co-founder of Databasix. We're based at Harwell. I'm a little bit passionate about data protection and privacy, and hopefully that will come across in the webinar. And I've got almost 20 years of experience working in data management and information governance across public and private sector. But that is enough from me. So let's get into the main meat of the webinar. So one of the questions I have had more than one occasionally, and more so recently, is that I can't take photos at networking events. Now, you absolutely can take a photo at the networking event. The regulation does not prevent you from doing that. If you are taking a photography at an event, which could be a sports event, it could be a festival, or it could be a networking, or even a trade show for that matter, a lot of the people in the foreground are considered to be in the public area. Therefore, data protection doesn't apply. However, what I would suggest, and we do recommend, is that in advance of the event that you are hosting, or if you are attending one, hopefully you're being notified that there will be photography taking place. If you prefer not to have your photo taken, you are entitled to that. And you should be able to let individuals know, maybe just by a simple dot on their jumper or their shirt, that they do not want a photo taken or a photo of them within it. So simply, when you're about to take the photo, anyone that doesn't want to be in it can then walk away, and the photographer also knows what to look for. So yes, you can take photos at events. GDPR doesn't prevent that, but as a way of being transparent, inform people that you are intending to take photos. If you want to take individual photos, it's best to get consent, as well as advising them how you intend to use that photo. The other common question that we get asked quite a lot, and I'm not quite sure how this came about, is that when you're at networking events or you've gone to a conference or a trade show, that you can't exchange a business card without first getting consent. Now, I don't know about you, but that would be incredibly awkward to say, can you please tick the box on my business card for consent? And it's really not necessary. The way to look at this is that there is a legitimate interest between you and the other party, where you are having a conversation, you're looking at potentially building opportunities with that individual, whether it's collaboration, potential new customer, or just someone who you feel will be good for your network and could be a strong referrer for you. There is a legitimate reason for that. And one of the bases within the law is legitimate interest. So the answer is you can absolutely exchange business cards. You do not need consent for that to be the scenario, and you can proceed to follow that up with the individual. What I would urge against is simply collecting business cards and then adding people to your mailing list. What you want to do is build a relationship with that individual, and then you can direct them to your marketing materials should they then wish to opt in to your newsletter. So you've got a business conversation going on one part, and then a marketing opportunity in terms of getting them onto your mailing list. So what we suggest that you consider is and I think there's been a lot of confusion in the past, probably 2 years, and I'm sure you all got bombarded with consent requests last year, is the understanding between the basis of consent versus the basis of a legitimate interest. So for me, I think the key thing is for you to write down what's the purpose for you holding that information. So you want a business card so you can engage with someone you've met at an event, and you want to continue that conversation. You want to be able to update people in terms of marketing materials. So you want them to opt in to your mailing list. You may wish when they're on your website, so you've not yet had that face-to-face conversation, but you may be encouraging them to download a white paper that shows your expertise from your website, and that you are telling those individuals that you will follow up following the download to have a conversation with that individual based on the fact that they have downloaded that document. And again, that's a legitimate interest. On your website, you may also have the option for people to sign up with an email address and opt in to your email newsletter. So what happened last year was probably 80 to 90% of a lot of marketing departments absolutely went out and asked for consent. Their marketing databases got reduced to almost nothing, and they were at a position of, well, what do we do now? So what I would suggest for you to do at this moment in time is, what's the purpose? Is it fair? Is it legal? And what legal basis are you going to rely on? Is it consent or is it legitimate interest? Now, the one thing I would urge anybody on the end of the webinar is, if you are going to rely on legitimate interest, you absolutely need to complete the legitimate interest assessment. It sounds quite overwhelming. It really isn't. It's really about what's the balance between your interest and the other party's interest. Is it necessary? And are there any alternatives? And if there aren't, then you should be able to pass the legitimate interest assessment. Always give people an opt-out if you are going to rely on legitimate interest. Now, this was quite a funny one that I heard, not so much for the members, but the question was, I have heard that we cannot email customers about critical updates. So there was a leisure centre was improving its changing room facilities. It did not notify any of its paying members to let them know. So when the members turned up to use the facilities, the rooms were closed, and they received quite a lot of complaints about this. Their reason was, well, we didn't have consent. Now, in this scenario, and I'm sure you would agree, that members were frustrated because they expected, as part of their membership agreement between themselves and the leisure centre, that updates like this would be part of their normal everyday communication from the leisure centre, and it's part of the contract, it's part of their membership fees. So consent is irrelevant. So again, I come back to the point of, you can absolutely contact your customers about, for example, your office is going to be closed for a period of time, or one of your members of team is moving on and is going to be replaced with a new member of the team, and you want to introduce them to your customers. That's an update. That's not marketing material. If you want to talk to your customers about a sale that is going on, or you want to urge them to buy something, then that is a marketing message, and hopefully your customers have opted in to your marketing campaigns. The next one is, because a lot of people went through their marketing databases and and their CRMs, and they reduced a lot of their contacts, they had very little to prospect from. So they had little opportunity to go out and find new leads to generate more business into their organization. And to be fair, that's what we're all about. We want to be able to continue to grow companies. We need to win work. And sometimes we don't do that via networking. We have to do that by accessing data. And one of the ways that you can do that is via email lists. Now, one of the questions has been that you can no longer buy, or I can't buy an email list anymore from a data broker. And again, I don't know if any of you have tried this, but if you do buy a list from a data broker, there are certain responsibilities on you as the organization that is purchasing that list. So what you need to make sure is that the organization, whether they be a third party, a lead generation company, or a data broker, you want to make sure that firstly, they can demonstrate that they've obtained this data fairly. So they haven't scraped websites or LinkedIn or various other databases, or they have downloaded information from corporate sites that they shouldn't, and they are now selling this to you. So the first question is it fair in terms of how they've obtained that interest, that list, and is it legitimate? So what you want to be able to ask them is for them to evidence it. So who are the people where did they source that information? Can they demonstrate that everybody that's on that list has consented to marketing materials, and more importantly, to marketing materials for the industry that you work within? It's very important that you have that, because if you market to those individuals and they write back to you and say, I have no idea how you got my contact details, I do not wish to be marketed to, they may choose to complain to the Information Commissioner. And there are some pretty extreme scenarios where companies have been fined because of the electronic communication. So you don't want to be in that position. So just do some quick checks at the beginning. Before you buy, is it legitimate data? Can the company demonstrate they have consent from those individuals? And then what you want to do is when you've got that list, one of the requirements under the regulation is that you inform those individuals that you have their data and where you've sourced it from. So there's nothing preventing you from sending an email to those individuals and saying, hi, my name is X, I'm from company XYZ, I've obtained your data from a third party, and by all means name the third party that you've obtained the information from. I'm contacting you because I believe that you'll be interested in our products and services. If for any reason you are not, give them the option to opt out. If they don't opt out and they wish to continue that conversation, then you've got a genuine potential prospect on your hands. What you shouldn't do is just buy that list, put it into your CRM, and market to those individuals without giving them any kind of context as to who you are, and maintain evidence that you've had those conversations with those data brokers. On a similar vein, you may use telemarketing companies. So rather than using electronic communications, you may feel that the way forward is telemarketing, and a lot of people, even telemarketing companies, have been a little bit concerned that their services are no longer viable under the regulation in terms of contacting prospective customers. And again, that's not true. As you would have hopefully picked up so far, you as the organization that is potentially going to buy telemarketing services, or you're going to introduce that option within your business, you need to justify why you're processing that data and why. So, for example, you want to be able to contact operations directors at science and technology companies within the Thames Valley area, because you feel that you have a fantastic product or service to offer them, and the best way that you feel is by phoning them to start that conversation. Now, the point about making sure you uphold the individual rights is, I'm sure you don't like being cold called. So it's about making sure that when you have that conversation, or when that telemarketing company is having that conversation on your behalf, the individual has the right to say, no, I'm not interested. Now, if they say they're not interested, there needs to be a process by which you can record that decision. So what you don't do is you recontact that person after they've already told you no. So please make sure that you remember individual rights when you're using telemarketing. The other check that we always suggest that you do, and it applies both to individuals if you're doing business to a consumer, or business to business, there is what is referred to as a corporate telephone preference list. You can Google that and it comes up, and companies will register telephone numbers. And if they're registered, what they are indicating to you that they do not wish to receive telemarketing messages. So be mindful, whoever your customer is, whether it be an individual within a business or an individual customer, that you are not contacting someone that's already told you no. Finally, and just as important as the others, if you are outsourcing this piece of work, so you may have generated a prospect list yourself. So for example, you may have bought the list from of telephone numbers, or you may have had a list of contacts that you want to reach out to. You may be passing that information on to an outsourced telemarketing company, along with personal names and as well as a telephone number. You need to make sure that you have appropriate contractual clause in place between you and that company, because if that company sells that information without telling you, and it has happened, or they hound your prospective customers unnecessarily, which has also happened, the fault will lie with you, unfortunately, because you are the controller. So just make sure that, there are many telemarketing companies out there that are very open to the and are very above board to the contracts between yourself and them, and they can demonstrate their compliance with the regulation. So have what is referred to as a data processing agreement in place if that telemarketing company is processing your information on your behalf to prospect for you. A common one is, I can't recontact old customers. Now, I would say that you absolutely can, because if you've done business with them in the past, you have a legitimate reason to reach back out to them and say, hi, how are you doing? We noticed that you haven't bought from us within the last year. Is there any chance you have 15 minutes for a conversation? Because we'd like to talk to you about what we currently have on offer. Or we've got a new product that we're developing, which we feel that you might be interested in. Now, what I think is incredibly important, and I'm sure you're all very familiar with it, is that everybody will have a different sales cycle. So if your product that you have a long sales process, so it takes you between 1 to 3 years to actually get a prospect from being originally interested to actually signing off and paying you for the product, it's not unusual for you to not have heard from them within a couple of years, because they may have gone quiet. So your sales process might be every 3 years. If we haven't heard from a customer or an ex-customer, we will reach back out to them and see how they're getting on. You may wish to contact them more regularly, of course, but what we're trying to enforce here is that there's nothing wrong with a client going quiet. And if you have a lengthy sales process, it's perfectly acceptable to retain that information on your marketing database or your sales system and say, if we haven't heard from them within 3 years, you're not going to delete them. You're going to try to contact them to find out if they are still interested in hearing from you. Now, you may have a much shorter sales process. So your sales process will inform your retention period. So how long can you hold on to contacts or old customers that haven't engaged from you, for you then to contact them. Now, the question is, if you have contacts on your database from old customers, they haven't bought from you, are they still accurate? Do you still have accurate information on them? Is the individual still in that business? If so, you can remove the individual's contact details and obviously retain the customer. But just be mindful that, yes, you absolutely can, and we encourage that you do contact your old customers, but know how long of a retention period that you should have, because at some point in time, you may wish to delete those contacts because they are no longer valid for you to have. Now, this is not a GDPR says no. This is a slight misunderstanding about what information is classed as in the public domain. So if you were to go to our website, for example, you would see both my email address and the email address of my business partner. Now, my email address is on my website because I'm more than happy for people to contact me and talk to me about data protection related issues or data management issues that they wish to explore with me, or their vendors who feel that there's a potential collaboration. My email address is not on my website for it to be taken off and to be just added onto a mailing list because someone feels that my information may be of interest. So a business email address is absolutely personal data. Therefore, data protection does apply. If you remember the earlier slides, I said that you have to have a lawful basis. So obtaining my information from the website is not consent. So what you'd want to do is you'd want to be able to email me, for example, or phone me and say, "Hi, Kelly, I've seen your details I've got your details from your website. I'd like to talk to you about this most amazing product that I feel that you might be interested in. Is this something that we could talk about?" Now, if I say, "No, I'm not interested," then don't put my information in your database and make a note, that Databasix is not a company for you to reapproach. However, I might be like, "Absolutely, let's have a conversation. I want to meet with you, come into my office, or let's have another talk." At that point, you've told me where you've got my information from. You've given me the option to opt out, of which I've said, "No, I want to continue the conversation." By all means, then add my contact details into your sales system. And you may then give me the option of, we also have a newsletter. Would you like to be added to that, or even direct you to our website? Can you please sign up to our newsletter? So there are different ways that you can lawfully use my information that you've obtained from my website. Now, the other no, and this happens a lot, is that, and I only saw this last week in a totally different forum, someone was going through all of their 2,500 individual contacts that they had on LinkedIn. They were taking the business email address from that LinkedIn page, and they were adding it into their CRM to send them email newsletters. Now, LinkedIn and Facebook, for that matter, are absolutely clear that you cannot data scrape information from their systems and pull it into a CRM. What they expect organizations to do is, through the messaging functionality on both of those platforms, is to connect, start a conversation. If there is interest in terms of taking that conversation further in terms of a phone call or maybe a meeting, at that point, you've got a legitimate reason for processing that information outside of LinkedIn and putting it in to your database. Scraping data is not acceptable and it's not lawful. So I would urge you not to do it. And if you read LinkedIn's terms and conditions, they are very clear about that in their policies. So please don't do it. But absolutely, build your connections through LinkedIn, and hopefully through that, you will get some awesome new leads that you can pursue, and you'll win a lot of work. So one of the rights that people very rarely talk about when it comes to the regulation, and one that is very important from my perspective, from a sales and marketing perspective, or even from a digital marketing perspective, is the right to be informed. So you'll see here that there was a company, a digital marketing company, that unlawfully processed business people's email addresses onto their system without the individuals knowing this. So they could have avoided the €220,000 fine had they contacted the individuals for whose information they had. The regulation says within 30 days, and said, like we've already discussed, who you are, why you have their information, what you intend to do with it, and giving them the option to say, no, I'm not interested. So always remember the right to be informed. It's not just about the right of access or the right to be deleted. In the very first instance, we all have the right to know how companies are processing our information. So a little call to action: where you have obtained data from third-party sources, please make sure that you advise the individual whose data you wish to process why you have their information and how you intend to use it. So in the agenda, I said I wanted to talk about very quickly the use of cookies. So the question I have for everybody at the end of the webinar is, have you have people who are visiting your website said yes to non-essential cookies? So what I mean by this is they've not just clicked OK on a cookie banner. What you have given them the choice of is, do they wish to opt into Google Analytics? Do they wish to opt in to marketing cookies? And if you sell any information, and it typically is advertising industry, do you consent for advertising cookies? So what you need to do as an organization is, if you are using cookies, can you demonstrate that all the visitors to your website have ticked, positively opted in to non-essential cookies such as analytics, advertising, and marketing? Now, that should be there are lots of cookie consent tools out there, and if you're interested, reach out to me. I'm happy to let you know what they are. Alternatively, look at our website. We've got a cookie consent that comes up, or Google cookie consent tools. But you cannot assume that individuals visiting your website are okay for Google Analytics. You absolutely can process not essential cookies, and these are, if you have a website that you allow people to buy things from you online and you have a basket, then you need a cookie to be able to manage that basket. If you need cookies to know how busy your website is, so you can manage it. So they are essential, non-essential, or anything else. So please take a look at this. The Information Commissioner made a change this year in terms of her definition of what consent is. So whilst a cookie isn't processing personal data, the consent is about storing the cookie on a personal device. So seek opt-in for non-essential cookies. And then finally, what I want everybody to think of in a positive light is that GDPR shouldn't be seen as a barrier, and people shouldn't be using it as a barrier against you for working with you. So GDPR is a framework that allows you to have a competitive edge if you use it well. So if you are fair in your processing, if you're lawful in how you're processing it, so it's a condition of a contract, or it's consent, or it's legitimate interest, and you are absolutely transparent in everything that you do, whether it be the use of cookies, whether it be the use of telemarketing, third-party data lists, or simply, you're trying to follow up from a networking event, remember to inform people, and then you can put all of that into your fabulous privacy policy so people know how you use their information. So that's a whistle-stop tour of some of the questions I have. The opportunity now, before I do my little 60-second pitch about Databasix, is, do you have any questions? Is there anything that I've said that you're like, oh, I'm not sure, Kelly, that doesn't make much sense? Or is there a burning question that I've not covered that you routinely get told, no, you can't do that because of GDPR? I'm more than happy to answer those questions. Okay, so one of the questions that's just popped up is that a company is regularly asked by customers to provide previous customer references within a tender. Do we need consent from previous customers to share their name, location, and contact detail to act as a reference? Or can we rely on legitimate interest? So you can testimonials where you're not asking, where you don't have, so testimonials you don't need consent, but I would say very much like references for employees that are going on to another job. It's probably in your best interest just to say, look, typical tender process requires us to ask this. It's in their interest. So I would try going down the legitimate interest route. There's nothing wrong with you exploring with the previous customer. Look, we typically get asked this, is there anything, would you object to that? If they say no, then you've got a list of people that you can regularly rely on as referees for you. So do the legitimate interest first. Go on, if you want the what an assessment looks like, I'm more than happy to provide you that. But I would say you could probably rely on legitimate interest, to be perfectly honest. Are there any other questions that we've got? Whilst I'm waiting for some questions to pop through. If you, so Databasix, we typically provide practical data protection advice and guidance to small, medium-sized companies within the Thames Valley, typically those that are frustrated by GDPR being used as a barrier to business, or they are uncertain as to whether or not their staff are confident in the policies and procedures that the organisation has and are following them appropriately, or they are uncertain if their policies are still fit for purpose. If any of that resonates with you, we may be able to be of help to you. We do a whole range of services. Now, here's an example of how I would ask for whether or not I can follow up with any of you. So what I would ask is, if any one of you is interested in a follow-up call with me, please indicate by typing yes in the text box here. If you don't type yes, silence, or you say no, I will not follow up with you. You'll absolutely get a copy of the webinar, but you'll get no follow-up call from me. So all I ask is if you can indicate yes if you'd like to have a follow-up, no obligation 15-minute call with me. If not, that's absolutely no bother whatsoever. So then finally, here are my contact details. And so if you'd like a conversation with me offline, or you just want to follow us on LinkedIn or Twitter or Facebook, here are our contact details. Oh, a quick question. Okay, so if we wanted to close down a social media channel, are we allowed to contact the people to let them know? There'd be no reason why you couldn't, using direct messaging in that social media platform, send out a message to say, we're closing down this channel. You could redirect them to whatever is your new means of contacting individuals. So you might be moving away from Twitter and putting all your social media into LinkedIn. I would also use the front-facing part of that social media channel to tell people when you're going to close down a social media channel and redirect them to what is your new effort, because you don't want to lose out on people following you. So use direct messaging as well as the actual platform itself to say where you're moving onto, or even direct them to your website if you are deciding that social media is not for you at all. Okay, we've still got a few more minutes. If people do have any questions, please use the forum or the text box to do that. And like I said, my details are on here. I see I've got a few people typing, so I'm just going to give it a minute or two. Okay, so I've had a question which is a vendor application by a client. I'm a one-man band. Do I have to respond to them? I would say to you, what is it that you're processing on their behalf? I had a lot of customers last year that were received unnecessary processing agreements because they were simply holding their staff's contact details to invoice them at the end of a contract. So firstly, what are you processing? Are you processing anything on behalf of that company? If so, what are you processing on their behalf? At which point, fill out the application. If the vendor application is not relevant to what you do, I would turn it back to the client to say, what role is it that you feel that I'm doing to fulfill this part of the contract? Because it may be absolutely unnecessary. But if you are processing, regardless of what size you are, even if you're a one-man band, if you are processing personal data on behalf of an organization, then you are likely to have to you're likely to have to complete a simple data processing agreement. But if you want, I'm happy to have a conversation with you offline. Okay, I've still got some people furiously typing. So if there are any questions after this, you might be like, okay, I've sat through and listened to it. I need a bit of advice and guidance. You can reach out for me. So, okay, this is a good question. So, company's been at a job fair and we're collecting job seeking candidate names on a form when they visit our stand. Do we need consent? No, you don't. You're at a job fair because you're interested in, so it's a legitimate interest essentially. So you're there to be able to obtain potential candidates to come work from you. Those candidates are there seeking to either move job or to start a new career or to start their career as a whole. So you do have a legitimate interest. I think the best way to handle that is to say to the candidate when they pop up to your table, thanks for giving me your CV. We'll be back in touch within the next 24 hours, 48 hours to take this forward as to whether or not you're going to take their CV forward. What I would absolutely say, if there are CVs that you have received that you have no intention of taking any further forward, do not retain that information, because you will not have a lawful basis for holding the CV as it is. But do the legitimate interest assessment. You should have absolutely no problem with that. You do not need consent to take the candidate's CV from them. Again, if you want an example of what a legitimate interest assessment looks like, please email me. I'm happy to direct you to where you can get that assessment. Okay. So if there are no further questions, I'd like to thank you all very much for giving me your time this lunchtime. I hope that it has been insightful. We do have other webinars that go on every month. You're more than welcome to sign up for them. I hope you all have a fantastic day, and hopefully you'll realize that data protection isn't a barrier, actually will help your business grow. So thank you all very much. Have a great day.